Hello and welcome to MIAB's webinar on Vicarious Liability in Dental Practices. My name is Tristan Lennox-Gentle and I'm one of the directors here at specialist medical insurance broker MIAB. In this session I'd like to explore vicarious liability, particularly focusing on how it can affect you in a real-world business situation and what you can do to mitigate your exposures. We'll also explore common misunderstandings about vicarious liability and close with some tips as to how you can review your own cover for adequacy. Vicarious liability refers to a situation where someone is held responsible for the actions or omissions of another person. In a workplace context, an employer can be liable for the acts or omissions of its employees, provided it can be shown that they took place in the course of their employment. Many employers are unaware that they can be liable for a range of actions committed by their staff, and these can include bullying and harassment, violent or discriminatory acts, or even libel and breach of data protection rules. A very recent example of vicarious liability in practice is the case of a disgruntled, now ex-Morrisons employee publishing the salary information of over 100,000 staff online. The Court of Appeal found Morrisons liable for the employee's actions through the vicarious liability principle, and the compensation awards, still yet to be determined, could well be staggering. In a dental setting, the risks are amplified by the added element of clinical negligence, and this can often lead to the practice being bound in litigation against an employee, even if the wrongdoing is predominantly attributed to the individual clinician rather than the practice as a whole. This is often as a result of a business being perceived as having deeper pockets than a private individual, but more commonly because the employer in law is ultimately responsible for the actions of the individuals it employs. The principle of vicarious liability is utilised more frequently when care is shared between multiple clinical staff. For example, a patient might require an emergency procedure which is undertaken by the first available dentist at their practice due to its urgency. A follow-up then might be scheduled with the patient's usual dentist, and then a hygienist might discuss and agree a maintenance plan for ongoing management of that condition. Because of this multi-touch care, it can be hard to attribute wrongdoing to any one person, and so, for ease, solicitors will address litigation at the employer as a cover-all to the claim. We must also consider former staff, for example, an associate no longer employed by your practice, or a self-employed dentist who operated under your trading name. It's at this point we should highlight that self-employed and contracted individuals are considered employees in the eyes of the law, subject to passing specific measurables. These three main test criteria relate firstly to the level of control the employer has over the individual, for example, whether they were wearing practice uniforms and what working hours they were required to do. The second is the extent to which the individual's contribution is integral to the business, and the third are economic factors such as mutuality of contract and of workers' rights. These points can be brought to life in the case of Whetstone versus the Medical Protection Society from 2014, in which the presiding judge confirmed the principle of vicarious liability in their summing up. The judge was quoted as saying, "In the circumstances of the present case, as I have pointed out, Mr. Whetstone exercised a high degree of control over Mr. Sudworth and his activities. Not only was Mr. Sudworth bound to follow the policies prescribed by Mr. Whetstone, but he was to attend to provide his services at times also prescribed by Mr. Whetstone, and to charge fees for his services again fixed by Mr. Whetstone. Mr. Whetstone certainly had an organisation, the practice, which undertook the provision of dental treatment to patients, and Mr. Sudworth participated in that organisation and was integrated into it. He provided Mr. Sudworth with the physical means to undertake the provision of dental services, both in terms of the necessary equipment, but also in terms of the necessary supporting staff. And in no meaningful sense was Mr. Sudworth an independent dental practitioner merely taking advantage of premises provided by Mr. Whetstone. Mr. Sudworth could not decide of his own choice when to work or what to charge for his services. And when the Sudworth contract came to an end, he couldn't take his patients with him or their records. It seems to me that the relationship between Mr. Whetstone and Mr. Sudworth was as akin to employment as one could get in a relationship deliberately structured by contract to avoid an employment relationship. In the event of a claim against individuals no longer employed by the business, deflecting the claim is only viable if the employee can be traced and has maintained adequate indemnity for the period of time they were working for you. Otherwise, in law, the business should stand ready to assume responsibility for meeting the claim. The default position is that employers are always liable in common law for the actions of their employees at work. So, in a civil case, it's the employer that gets sued and not the employee. However, each case centres around whether the employee was at work at the time, i.e. acting within the scope of their employment, or, as the law defines it, on a frolic of their own. The basic idea is that an employer cannot be responsible for the actions of employees that cannot be reasonably foreseen. For example, injuries resulting from pranks. In a recent case, a pharmacist attempted to claim £58,000 in compensation from the NHS after she sustained damage to her lower spine when a fellow employee deliberately pulled her chair away as she sat down. She claimed the NHS Trust was indirectly liable for her colleague's act of folly. However, the judge dismissed the case, ruling that the prankster was acting outside of the scope of his work. Such rulings aren't a licence for employers to ignore acts of ill discipline, especially when they can be reasonably foreseen, such as an employee with a history of poor behaviour or poor professional standards. In such cases, the employer should still be liable, but it does give some comfort that an employer cannot be exposed to behaviour and for behaviour that could not be reasonably expected under usual circumstances. Similarly, other recent case law supports that where adequate records and training demonstrate competency, the employer has a stronger case to rebuff litigation back to the individual. However, this can obviously cause poor relations between an employer and employee, and for that reason is rarely exercised. Typically, a dental practice will operate under a singular trading name, and it will be led by a principal owner and supported by the services of associates under contracts of employment or on a self-employed basis. Associates may sometimes be drawn from outside the UK to practice, and while they may have indemnity to cover their activities at the time of working, often the challenge arises after a clinician returns back to their home country. As an example, let's consider a dentist practices for 3 years, but then after practicing for those 3 years decides to return back to their home country on a permanent basis. Subsequent litigation arises, naming that clinician, and the negligence claim is brought then against that ex-employee dentist. The question there is, what happens next for the dental practice? In order to avoid liability, the dental practice will need to trace the former employee. But of course, you've got those challenges of finding the individual, enforcing UK law internationally, particularly in Europe post-Brexit, or hoping that the clinician has maintained indemnity beyond their employment with you. It's highly likely that the dental practice will be held to account for the actions of the now ex-employee and the compensation awards that will inevitably follow. Unlike international employees, where the challenge is locating the individual, self-employed individuals present a completely different concern. Simply put, they will protect your interests while they're working for you, but will they protect your interests when they leave? While a dentist may maintain indemnity to cover their employment, It is simply a matter of good faith that that same dentist will maintain indemnity to cover their work retrospectively. Occurrence-based coverage eliminates the need to retrospectively cover past works, but it's not without its risks, as most occurrence cover is offered on a discretionary non-insurance basis. Therefore, if the provider declines to support the claim, the practice is back to square one and once again liable for the actions of others and the awards associated with the alleged negligence. With such a complex matter, it's not uncommon for practices to become confused with where responsibility starts and ends. Some practices assume that because a principal dentist has indemnity, that it automatically extends to the business name and the staff within it. This is rarely true, and in order for that cover to apply, you will need to request a specific extension from your indemnity provider. Another misconception is that not all staff need insurance. Clerical staff present almost as much risk as clinical staff, and as we've seen, bullying, harassment, and clerical errors can cause patient detriment, and they're all probable causes for litigation against a business. Equally, if a dental nurse leaves for a career change, and they fail to maintain indemnity, and a subsequent claim arises in relation to the work they've conducted for you, it will be the practice that picks up the tab. To further clarify, it's also unlikely that the practice's commercial combined insurance will support in the most instances, as such policies tend to exclude negligence as a standard market exclusion. Even in the event of cover being provided, legal cover is regularly capped at £100,000 or maybe even £250,000 per claim, and this is often an inadequate limit for indemnity given the relative size of mid to high range compensation awards over recent years. Claims can be targeted anywhere, and with challenges in tracing former employees, discretion of indemnity providers in supporting claims, and former employees failing to maintain indemnity for past work, the business is rarely safe from litigation. Once an employee leaves your practice, you relinquish any control over their indemnity arrangements, and that's assuming the clinician maintains indemnity and doesn't leave the profession entirely. You lose the ability to influence the scope, adequacy, and extent of the coverage, and in fact all of those elements are down to the former staff member to ascertain. If their cover is inadequate, it's essential to consider a contingency. So we recommend that you should insure where it's economically viable to do so. Many scenarios for which employers are vicariously liable for the acts of employees will be covered by a professional indemnity insurance, or to a lesser extent, an employer's liability or public liability policy. That's why it's important to conduct a review of your insurances. And it will be worthwhile, it's time well spent, because you will be able to identify the exact extent of your policy covers, not only for claims made against the business, but against individual clinicians. Many claims-made insurance policies will flex to structure cover for the business as a whole, including all staff on both a contingent basis, where cover is in place for the primary policy of the practice, but in the event of that failing, the contingent cover steps in as a backstop. Equally, negligence claims arising from former staff will be accounted for under these types of policies by placing these personnel on what's known as a run-off schedule. This allows the principal of the practice to be in control of the indemnity and to not have to rely on former staff to protect the principal's interests. It's really important to train and educate to take all reasonable steps to guard against the actions of rogue employees. And this starts with a robust recruitment process, making sure that CVs are accurate, that references are followed up, and once that individual's working, to make sure that they are fully trained and that there's a clear audit trail to evidence this. The biggest piece of advice that we could give any of our customers is to not rush. Price and value are rarely the same thing, so it's important you think about your insurance with care seeking advice where appropriate to ensure your arrangement offers the most suitable protection, whether that's run-off cover, GDC defence, PR and crisis mitigation. They're all types of cover which add value in their own way, but not every policy includes them. Dental indemnity is written on either a claims made or a claims occurring basis, with the latter often being on a discretionary basis and usually provided by a defence organisation. In a recent government consultation, the Department of Health and Social Care notes that the risk of providers of discretionary indemnity facing a situation in which they do not hold sufficient financial resources to support healthcare professionals may be increased by an absence of appropriate regulatory oversight and transparency. Providers of discretionary indemnity, principally the MDOs, are not required to disclose their full financial position in their audited accounts in respect of such covers. They're not subject to the same standards of reporting, disclosure, and oversight by regulators, and therefore are not the same as insurance companies. Regulated healthcare professionals may therefore have less assurance about the extent of their financial protection or, conversely, exposure, and patients and the public may have less certainty and confidence in the extent to which recourse is available. It's important to understand what type of policy you have, as it will determine what you should be looking out for. As an example, a good claims-made policy will have at least 3 years run-off cover, meaning that under certain circumstances, claims can attach to your policy for a minimum of 3 years after the expiry of cover. It should also be regulated and accompanied with a comprehensive policy wording outlining your cover. And in some instances, policies now are available with run-off periods of anything up to 10 to 15 years. The policy should extend to note your business as an insured entity as well as the clinicians within it, and consequently afford suitable protection against claims where your business is named in joint legal action. Your excess should ideally be nil, and the policy should offer unlimited access to a dental legal helpline to enable you to access qualified advice should you need it. Thanks for taking the time to listen to me today. I hope you found this short presentation informative, and if you wanted to get in touch with me or one of our specialist team with any questions about the issues raised here in this presentation, or simply want to explore alternatives to your current arrangements, contact me on the details on your screens now. We look forward to hearing from you really soon, and thank you very much again for listening.